party will have 15 minutes in which to argue their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium and keep track of the time, and I will let you know when you find whatever minutes you want to take. We are being visually and audibly recorded, so please try to remain behind the podium here as much as possible. We have read your briefs and we're ready to proceed with DeWine.
Thank you very much. May it please the court, I am Alan Medvick. I'm here representing the appellant, Joel Helms, in this matter. Before I get into the assignments here, I would do a little bit of housekeeping. There are a couple of typos in the brief. One rather glaring, probably not particularly important. I reference the effective date as 2016. Obviously, that was December 1st, 2008. That's the date that's sometime after the brief was filed. A little more insidious throughout. I referenced the amendments to subsection A of Article 1, Section B, 19B. The effective date of the entire statute, 19B, subsection 19B of Article 1 of the United States Constitution, took place on December 1st, 2008, and it's the entire statute that is at issue here. We're here regarding granting summary judgment in a case involving riparian rights and a foreclosure action and a counterclaim for declaratory judgment regarding that amendment to Article 1 and the creation of Article 1, Section 19B of the Ohio Constitution. And to back up, may I reserve 5 minutes for rebuttal?
Yes.
I apologize. The relevance of the statute, the language of the statute is not necessarily important here today. What is important is that the sole basis for granting summary judgment was a claim of res judicata and issue preclusion regarding that statute when that is an impossibility. It's the appellant's argument that there has been no prior proceeding ruling on the merits or the language of that statute. There was a trial involving the state and my client in 2008 regarding claimed pollution of some wetlands that my client owns, while obviously my client disputes that, and he lost those proceedings at trial. That trial took place in September and concluded in September of 2008. The statute at issue did not take effect until the 1st of December of 2008, well after any evidence was heard. The sole basis for the claimed res judicata is a motion for a new trial, and in that motion, my client's counsel, almost as an afterthought, cited this new statute as a ground. There were probably all of 2 paragraphs on that statute in his brief, and probably an equivalent amount in the response to the motion for a new trial. The lower court did not grant that new trial. He had no hearing regarding the statute. The trial court had no evidence presented as to the relevance, the retroactivity, or the applicability of this statute. I have moved at the lower court for declaratory judgment to consider those issues, and they have been denied out of hand. To be clear, I think there may be issues of claim preclusion. There may be some facts that have to be abided by, some presentations that were made at the lower court, and no one's disputing the privity of the parties here. But in terms of an issue preclusion, there is no way that a statute that was not even in existence at the time could have been precluded. The state's position and the lower court's finding essentially would render any claim for a new trial as a finding on the merits if it was denied, and that I think is wholly inappropriate. I don't know that the state could dispute that, if we had not filed for a new trial, or if we had not included any reference to this statute at that time, we would have a right to bring that declaratory judgment now. But without hearing a matter of 4 paragraphs has become a preclusive act. I think that runs counter to intuition. It runs counter to how law is practiced. There's been no hearing, there's been no presentation of facts, no argument regarding the intent of this statute, the intent of this constitutional amendment, which is designed to protect a landowner's right in his private groundwater. It is articulated as such. What the nature of that statute, the extent of that law, the applicability and effect of it on this case might be, we don't have an answer to, but those answers were certainly not provided at the trial in 2008. That there may be, we may ultimately prevail, that the state may ultimately end up in the same place is irrelevant to the case as it is positioned here today. You're moving for law, for consideration of a law that had not been in effect and has not been considered or heard in any way at the trial level. For the trial court to claim, and this is a motion for summary judgment, so obviously that's heard de novo, but I think even at an abuse of discretion standard, the trial court would have a hard time justifying finding a preclusive effect on the issues raised in that statute when they were never considered in any way at trial.
Isn't the state arguing that the same constitutional arguments were made in the civil action?
The state argued strictly that, and I think that that is not wholly accurate, that I think that they're, and even if they are making that argument, that's not.
We clearly have the same parties.
We have the same party.
Clearly have the same.
But they are not, they've not argued a factual issue. There's been no presentation or consideration of facts. The only presentation in the brief, in the summary judgment motion, was that this was an issue preclusion, not based in any fact finding. There had been no fact finding, there had been no consideration, there had been no consideration of the prior record.
You're talking about by the trial court.
By the
By
trial court in granting this summary judgment. It was wholly based on, and as articulated in the brief, that this was based solely on the motion for a new trial. That there may be down the line, after discovery, after presentation of facts, after the trial court decides what must be considered. I'm not ruling that out, that there may be a summary judgment motion here that will be considered, but at this time, at the level when we are strictly basing this on an issue preclusion claim, there is no basis for an issue preclusion res judicata finding in this matter. Now, are there issues that we may present below that might articulate how this statute is different? Certainly, but we've not had an opportunity to do that at this point. You know, what changes might apply and why they might require a different finding than, even with those facts as they might need to be accepted. That is something that my client was precluded from presenting because of the finding of the trial court stating that this was an issue that had already been resolved at the prior trial level, which is an impossibility to have considered the statute. The statute was not even on the radar. It was voted into law on November 8th in the election of 2008 and did not take effect. So it was some 2 months even before it was known to be recorded that it would have an effective date. There is no reasonable consideration that my client's counsel at that prior case would have presented evidence on this statute. Given all of that, I think finding summary judgment on a claim of issue preclusion is improper, and I would ask this court to overturn it. At this point, I reserve the balance of my time.
Good morning. May it please the court, I am Assistant Attorney General Mike Lutzkowski from the Office of Ohio Attorney General Mike DeWine. I work in the Environmental Enforcement Section in the post-judgment unit of that Our office represents the Ohio Environmental Protection Agency, or Ohio EPA, and the Ohio EPA asked the court to affirm the summary judgment found by this trial court below for two reasons. First reason is the state has a valid judgment, a 2008 trial court judgment, that it should be allowed to enforce. The second reason is res judicata bars Mr. Helms' current attempt to attack that 2008 trial court judgment. This is a foreclosure action, an appeal of a foreclosure action. It's not a civil enforcement action. It's not Mr. Helms' environmental case. He's had several of them. He's had several administrative appeals. This is the third court of appeals case he's had related to his violations. Those cases, those issues are resolved. We have a 2008 judgment, and Mr. Helms is simply trying to delay, hinder, or stop the enforcement of the state's laws and that judgment. He'd like to put on new evidence, conduct further discovery, relitigate a legal issue that's been considered and rejected twice by courts of competent jurisdiction, once by this court. Summary judgment is appropriate here because the state has a valid 2008 judgment. That was appealed and affirmed in 2011. The Supreme Court denied review. The state has a valid certificate of judgment lien on Mr. Helms' real property. There are authenticated documents in the record that demonstrate the state's judgment and non-payment of the judgment. This 2008 decision cannot be reviewed again. It's been affirmed. The Supreme Court denied review. Res judicata bars his alleged counterclaim. And Mr. Helms has no valid basis to attack the state's 2008 judgment. Now this claim is barred by res judicata because we have a prior valid judgment on the merits by a court of competent jurisdiction, in fact two. We have the same parties as in the prior action. We have the same transaction or occurrence that we're talking about, this 2008 judgment. This court held in 2011, and Mr. Helms argues he hasn't had an opportunity to present evidence on this issue of this constitutional amendment that came into effect just after his trial court trial, but not the decision. But he's raised it twice, and he raised it to this Court of Appeals, which in his brief, Mr. Helms claims that the court only reviewed that issue as to an abuse of discretion. But in assignment of error number 3, in the discussion of this court regarding that, there's no discussion about an abuse of discretion. This court looked at the facts in the case. They looked at whether they looked at the definition of a water course. They looked at waters of the state. They looked at the statute at Mr. Helms' environmental liability. And they said that even if the amendment, and the court considered the amendment in the light of the facts in this case, and said even if the amendment touches Mr. Helms' wetlands, it does not give Mr. Helms the right to pollute wetlands with improperly treated sewage. So that was one instance when a court of appeal, a court of competent jurisdiction, decided on the merits this constitutional amendment claim. Likewise, the trial court said when it denied his motion, his Rule 59 motion, it said there's no grounds to disturb the judgment, the amendment created no new rights, and it doesn't allow pollution of waters of the state. Now, Mr. Helms, in his motion, this 59A motion, referred and cited to sections 7 and 9. And 7 is a claim that the judgment was contrary to law, and 9 is that it was a result of an error of law. So in both instances in his motion, he's calling for a ruling of law, and the trial court gave him that, and this court has given him that. Both the trial court and this court decided on the merits of the constitutional amendment argument. So determining as a matter of law that it didn't affect his environmental liability. The state denied, or the Supreme Court denied review, so the state has a final valid judgment which it should be allowed to enforce. So otherwise, if this court, I think, should respect the sanctity of the state's final judgment and allow the state to execute on its judgment. Otherwise, what are judgments but meaningless words and worthless pieces of paper? Now, appellant has claimed, as I said, that this court didn't consider or didn't have an opportunity, or no court has had an opportunity to consider his constitutional argument, but it's been raised twice before courts of valid, competent jurisdiction rather, and it's been determined as a matter of law that this constitutional amendment didn't affect his environmental liability. So the state asks the court to affirm the trial court's summary judgment decision and allow the state to enforce its judgment.
Thank you.
Thank you.
Remember, you have 7 minutes and 27 seconds.
Um,
Or 5 minutes.
And I will try to be brief. I have just a few things. First of all, it is mischaracterization of the case as it stands below that this is only a foreclosure action. The trial court did allow my client, he requested leave and was granted leave to file a counterclaim for declaratory judgment regarding this constitutional issue that was before the court as a deck action. This is not solely a foreclosure action below. My client did raise this issue properly and it was before the court on counterclaim. This was a declaratory judgment action for this issue. Regarding the claim that the two courts of competent jurisdiction, I believe he's referring to the trial court and this court in prior action. There had the sole extent of the record regarding this issue is the raising of these issues on the merits. There is in the motion for, the raising of these issues in the motion for a new trial under Rule 59A. There is no consideration of any fact, any presentation of any argument, any presentation of any consideration of this amendment. There is simply a rejection of the Rule 59 motion. And neither myself nor the state have found any case law, referred to any case law that says that in any other circumstance that a Rule 59 motion could be considered a finding on the merits for purposes of res judicata. That case does not exist. I have looked for it. On the other side, there is no argument that this has been presented to a court of competent jurisdiction. This was what my client was looking to do, was to present this issue to the court at the lower court. To be told you don't have an opportunity to do that is it's a damned if you do, damned if you don't scenario. If he had been granted a new opportunity, then we would have, that obviously would not have been a finding on the merits of that case. It obviously would have been a new trial for consideration of those merits. Instead, by simply raising the issue rather than doing what we have done here and preserving that for a later declaratory judgment action, he is essentially have been told that without consideration of any of those facts, he now loses.
How does the entry deal with the declaratory?
What's that?
How does the summary judgment entry deal with the declaratory action? Does he say because, does the court say because of the rest of the cut it's now moot?
If we had not brought, I don't think there's any question, given the timing of the statute in consideration of the trial, it having taken effect after the fact, that if we had not raised, if my client had not raised the issue in a new trial motion, it would still be right for consideration as a declaratory judgment. That he then subsequently asked for that and was rejected should not cost him that opportunity without a presentation, without having it been considered. It is in status quo. There's been no ruling on the effect of that constitutional amendment at this point. And again, this court's consideration of that, whether the state would like to articulate that differently, was merely the Rule 59 motions are reviewed for an abuse of discretion, and I believe that is the finding at the conclusion of this court's opinion, was that the trial court had not abused its discretion in granting in denying the Rule 59 motion. I don't think that there has been a de novo review of that by this court in any way. I think that where we are is that this is a case that this is an amendment that has never been considered, and has never been considered against these facts. And I think to grant summary judgment based on issue preclusion is improper. I would ask this court to overrule that. The lower court to return this for further action.